सो फाइनली काफ़ी इम्पॉर्टेंट अपडेट है जो डिस्कस करने वाले हैं इस वीडियो के माध्यम से. सो प्लीज़ मेक श्योर टू शेयर दिस इज़ समथिंग रियली इम्पॉर्टेंट हेयर. सो द सबसे इम्पॉर्टेंट जो एक्सट्रैक्ट है उसको यहाँ पे डिस्कस करेंगे, जो कि एक्सट्रैक्ट है क्लियरली फ्रॉम द जजमेंट, सम एक्सट्रैक्ट फ्रॉम द जजमेंट ऑफ द हॉनरेबल हाई कोर्ट, सुप्रीम कोर्ट, जो कि इम्पोर्टेंट है हमारे लिए. सो दिस एक्सट्रैक्ट्स आर रेलिवेंट, जो कि अभी 7 मार्च को सेंड करा गया टू द IBA एंड पोस्टेड सेपरेटली. सो दैट इज़ वाई दिस इज इम्पॉर्टेंट हेयर फ्रेंड्स. Thus, the provision combined in Regulation 35 also make a incumbent entitlement for opting the pension on the basis of average emoluments. Thus, in our considered opinion, the view taken by the then Chief Justice Bikramji Sen, as he then was at the Karnataka High Court, and by the High Court of Madras, so taken by the Honorable Delhi High Court, cannot be said to be sustainable for the various other reasons to mentioned hereinafter. Thus, we set aside the judgment rendered by the Honorable High Court of Delhi, All India Retired Bank Employee Association versus Union of India, and affirm that the High Court of Karnataka, तो यहाँ पे आप देख सकते हैं, at Bangalore and High Court of Madras, the appeals filed by the banks are dismissed and the appeals filed by the association is allowed. Resultantly, let the amount which was due and payable to be paid with 9% interest be calculated and paid within 4 months from today. So ये है यहाँ पे important, within 4 months to today. The prayers which are made in the writ petition touching the aforesaid challenges are stated in the following manner. Issue a writ of certiorari quashing clause 6 of joint note dated 14th of December 1999, void which definition of pay for the purpose of pension was amended. So this amendment has civil consequences for the issue. The definition of pay for the purpose of pension was amended. So this amendment has civil consequences on the rights of petitioners and has been passed at the back of the petitioners. So this definition of pay is totally unreasonable and artificial. Clause 6 I did contrary to the pension scheme 1993 as well as Regulation 35 2 and 2 do of the Employees Pension Regulations 1995. So issue a writ of certiorari questioning the amended clause 2s of the Pension Regulation 1995 and 16 of the 7th BPS dated 27th March 2000. So this is important here. Void which definition of pay for the purpose of pension was amended. So this amendment has civil consequences on the rights of petitioners and has been passed at the back of the petitioners. So this definition of pay is totally reasonable and artificial. Clause 2s of Pension Regulation 1995 and Clause 16 IBID are contrary to the Pension Scheme 1993 as well as Employee Pension Regulation 1995. So respondents are estopped on the principle of promissory estoppel from enforcing and or implementing the said clause of the 7th bipartite settlement dated 27th March 2000. क्यों दी petitioners. So यहाँ पे आप देख सकते हैं. So issue writ or direction to declare the action of the respondent of reducing the rate of pension payable to the petitioners association from 50% of their basic pay to approximately 41% as arbitrary, discriminatory, capricious, and violative of Article 14 and 21 of the Constitution of India. So, issue writ or direction directing the respondent to grant the benefit of pension to the members of the petitioners association as being paid to the retired employees of other public sector undertakings, namely LIC and Reserve Bank of India. So pass such orders and further orders or orders as this honorable court may deem fit and proper in the facts and circumstances of the case. So in nutshell, following prayers are made quash clause 6 of joint note dated 14th of December 1999, wide which the direction of pay for the purpose of pension was amended. The main grievances of the petitioner is that the joint note and the settlement was entered into at the back of the petitioners and their associations was not made a party to the settlement. So ये काफ़ी important extract हैं. So some extract from the judgments of the Honorable High Court, Supreme Court that are important to AIRBEA and to us. And these extracts are relevant to the AIRBEA letter as well, dated 7th March 2025, which was sent to Indian Bank Association and posted separately. So friends, बहरहाल इतना ही. So that's all. So this is something really important जो हम यहाँ पे डिस्कस करना चाहते थे. सो प्लीज़ मेक श्योर टू शेयर दिस अपडेट एंड चैनल को फ्रेंड्स यहाँ पे सब्सक्राइब जरूर कर लेना. और एक विनती है आप सभी से, सो प्लीज़ सपोर्ट अस बाय ज्वाइन बटन. सो ज्वाइन बटन के माध्यम से बहुत नॉमिनल फीस है दोस्तों, सो दैट वी कैन कैरी ऑन एंड मेक ऑन द इम्पॉर्टेंट कंटेंट in relation to the operation. So that's all for the session. Please take care of and please like the video and subscribe to the channel friends. Thank you. Thanks a lot. We'll see you in the next video.